Okay, so I think we're about ready to start, and I think we all want to sort of get our education and run away into the hot night this evening. It's a bit hot to be sitting in front of a computer screen, but I'm going to be in very, very good company while we do that. It's lovely to see lots of squares that I recognise. And we've got two great speakers for this session on development in homelessness and judicial review. We have Derek Bernadi from Camden Community Law Centre and Sarah Steinhardt from Doughty Street Chambers. I think it's Sarah who's going to go first. But first, just a couple of announcements. So this is being recorded for later on. So just if you could switch your cameras off and mute, put any questions in the box. A few plugs. The July podcast is now out, so you can find details of that on the website. That's got Justin Bates and Giles Peaker on the domestic abuse bill. So that's available. If people can, if they're at a firm where they normally pay to attend the HLPA sessions, there are links to do that. Obviously, if you're in a situation where you're not able to, then that's fair enough. But if you are in a position to pay, then that's brilliant. Help us keep HLPA running. We have an advanced sort of save the date. So the HLPA conference this year is going to be, I think, online, and we're looking at the 9th of December 2021. So if you can save the date for the HLPA conference. And also we're going to be doing a members survey, hopefully in the next couple of weeks. So if you could have a look out for that. Any other questions or queries or anything, put them in the chat box, and we can have a look at them. And I'm sure Simon will let me know if I've forgotten anything, because suddenly there seem to be quite a lot of announcements. So I'm now going to pass over, I think, to Sarah, who's going to start with her presentation.
I'm just going to share my screen so that you can all see the slides. So fingers crossed this works. Hopefully you can all see it now. All right, so I have, oh dear, that's not moving on. There we go. So I have generously agreed to do the boring, geeky bit. And Derek is going to do the fun bit. So I'm like the stew, which is good for you, but not particularly exciting. And Derek is like the, I don't know, strawberry cheesecake that is going to, you know, give you a bit more interest at the end of it. So let's get on, because it's a lot of material to cover. So the big changes in judicial review are the introductions of the 2 new practice directions. There is also a 54C, but that's not something that we need to concern ourselves with. So we've got practice direction 54A, which effectively is sort of following on from Dolan and the Minister for Health and Social Care. And then there is practice direction 54B, which is dealing with urgent applications, and that is sort of following on from the case of DVP and the Secretary of State for the Home Department. Now, I have to give you all a bit of a trigger warning when it comes to the case of DVP, because if you're anything like me, it brings me out in a cold sweat. It's just every lawyer's fear of getting dragged in front of the court to explain yourself and the decisions that you've made, and to be told that you have got it horribly, horribly wrong. So we're going to come back to DVP, but sorry, it's coming. We are going to have to talk about it. So practice direction 54A, overarching themes. Well, there's some big changes. The most significant change is really that it's just a lot more prescriptive. There's a lot less about sort of broad themes about what broadly must happen, and a lot more finer detail about exactly how things should be done. And this really is a sort of, it's a codification of best practice, but the expectation.
You should try food.
I'm hearing somebody else, but I think we can carry on. So it's a lot more prescriptive, but it comes on the back of cases where there was a sense that the rules were being complied with sort of more in the breach than in the actual fact. And of course, there's a more political climate of being a lot more demanding about judicial review claims. And just in general, a sense that it was felt that in judicial review, somehow the rules didn't apply. So this is a lot stricter. It needs to be taken really seriously. There is a strong focus on being succinct and concise, which you might think doesn't quite fit with some of the other provisions that are in the new rules, which talk about including every material fact. So, for example, 54A, the claim form and the statement of facts and grounds. The first thing here is that the claimant must make proper and necessary inquiries to ensure that, so far as reasonably possible, all relevant facts are known. So this is a sort of codification of the duty of candour. And I think we're going to all need to get a lot more used to being very demanding of clients in terms of what they say to us. So challenging them on what they say. When they say, well, I can't go to this area, we need to be really clear, well, what else can you do? And why can't you go to that area? And is there any way that we can mitigate this? So we need to be really, really thorough in our inquiries in a way that we might perhaps have only done previously on out of hours applications. And we need to really internalize that. The claim form must then set out all the facts which are relevant to the claim, and any statutory provision which excludes the jurisdiction of the court, so out of the clauses. I don't think that's going to be something which which is particularly relevant for us, but the important point there is that, again, it's this emphasis on the duty of candour, this emphasis on putting everything which is relevant in front of the court. References to any alternative appeal mechanism, of course, that is more relevant for us. There may be cases where there would possibly be a Housing Act appeal. In those circumstances, I think we're going to need to be really clear about explaining why it is that we're not using that mechanism instead. Most of this is obvious. The statement of facts and grounds. I mean, this really is teaching us to suck eggs perhaps a little bit. Numbered paragraphs, but again, clear and concise. The main change here is the limit of 40 pages, and the expectation that most statements of facts and grounds will be significantly shorter. I don't suppose that page limit is going to be a particular problem in housing. What I would mention is the stating precisely the relief sought. I think we can sometimes be a little careless on being really clear about what it is that we want the court to do. And when we come to look at the case of DVP in a minute, we'll see exactly why that is incredibly important. The claim bundle, again, most of this is unchanged, and so most of this isn't terribly significant. But again, it's a lot more prescriptive. It does now need to include the decision which is challenged, which of course we would always do in any event. So if there is a Mohammed letter, it obviously needs to go in the bundle. Where we are challenging a failure to act or a failure to do something or a state of affairs where there isn't a decision, I think this rule probably means that we need to be a little bit clear about why it is that that isn't included, and to explain exactly what it is that is under challenge. The claimant must now produce a hard copy and an electronic copy, and there is new electronic bundles guidance, most of which hasn't changed hugely, but it needs to be a 20 megabyte core bundle if the bundle is going to be any more than that. So this electronic court bundle guidance, published the end of May, so still relatively new. Most of this, I think, are probably things that we're quite used to or at least getting used to it. So one PDF file, something which is usable with Adobe Acrobat and PDF Expert and so on. If you are seeking urgent consideration, which of course we mostly will be doing in housing, then the bundle shouldn't be more than 20 megabytes. Now, compressing a file down to 20 megabytes might make it unreadable. So it's really important that only the most essential documents go in the bundle, so that you can still maintain the quality of the bundle, and it can still be something which is usable. Pagination of the pages, again, you're probably all used to this now, but the numbering must go all the way through. So it starts from page 1 of the PDF, and that might include your index, so that the page numbering on the electronic copy is precisely the same as the page numbering on the paper copy. It must be bookmarked, it must be hyperlinked. I still don't really understand why documents have to be both bookmarked and hyperlinked, because I think you only really need one. But anyway, that's the rule. Default view must be 100%. I still don't really understand what that means. And resolution, again, it all gets a bit technical, but hopefully you're more used to this than I am. One thing to note is that the document must be text-based rather than scanned. So you can't just produce a paper bundle and then scan it in, or at least you're certainly not supposed to. If you don't have a choice about doing it in that way, then it must be OCR'd. So that means that it becomes searchable text that the judge can then use in that way. If you get to a hearing and there are further documents that you need to add to the bundle, what the new guidance says is that you need to essentially go to the judge and ask the judge, well, how would you like these additional documents? Do you want a supplementary bundle? Do you want them to be added to the original bundle? How do you want us to do it? So practice direction 54B. This is the practice direction on urgent claims, which, as I say, most of our cases are going to be. And this does mark a fairly significant shift, which follows on from the case of DVP, and also in general, an increasing use of the Hamid jurisdiction. So this was a case, deep breath, this is the case where the lawyers were challenging the detention of a number of individuals at the Penally barracks. And they were challenging the conditions of their detention, and they represented a group of claimants who all had disabilities and vulnerabilities. Now, the difficulty was that by the time the claim was issued, the claimants themselves had been moved. So they were no longer in in those barracks. Nonetheless, the relief sought, the urgent relief sought, was for an order that effectively everybody be moved, that the place be closed down and that everyone be moved. And the court held that the claimants didn't have standing in relation to that. So it wasn't for them, who had been moved, to argue as to what should happen for other people. And because of that, the case wasn't urgent. It wasn't urgent in respect of the claimants. It's arguably urgent in respect of other people who the lawyers didn't represent, but it wasn't urgent in respect of the particular claimants who had in fact already been moved. So what happened was that the judge referred the case to the so-called Hamid jurisdiction, which is where the court refers the lawyers themselves involved, usually both counsel and solicitors, to consider whether or not the court should refer those individuals to the regulatory bodies. And I mean, even the thought of it just sends shivers through me, really. But the point is that more fundamentally, the court in that case identified significant concerns, not only about that case, but more broadly about the use of the urgent procedure. And there's been a more recent case which is unnamed, as the court kindly didn't name counsel involved, which looked at this again and seems to indicate that courts are increasingly willing to refer lawyers where they think that the urgent procedure has been abused. So the new rules, Practice Direction 54B now requires that the N463 again should contain all the information required on the form. And again, this is something that we see in the recent unnamed case. And this was also set out in DVP. So it's not sufficient on the N463 to put C attached, and it's not sufficient to leave any question unanswered. Now, in this unnamed case, it's 2021 EWHC 1895. In this recent case, what happened was that an N463 had been filed in order to seek expedition of the case, but not to seek any sort of interim relief. And again, the court considered that that was an abuse of the urgent process, that it was against the whole thrust of the urgent procedure to allow people to make applications in respect of something that wasn't going to happen for 4 or 5 weeks' time. It just wasn't a legitimate approach. And really what the court said was that an N463 should be only for cases where interim relief is sought. So not just for expedition, but for situations where you need an order in your favour within 3 days or so. And if you're not in that situation, then you shouldn't be filing an N463. What you should be doing instead is filing an application notice and then chasing your application in the same way that you would in any other set of proceedings. So it's really limited what we should be using N463s for, and I suppose the scope of the urgent procedure in general. In terms of what the new practice direction provides for, so again, hard copy and electronic copy, all pre-action correspondence, all communication with the defendants concerning the application, a draft order, of course, any request for an expedited timetable. Now, it's interesting that the rules provide for where an urgent application is for interim relief. But as I say, the recent case law would tend to suggest that actually you should only be doing it where you need some form of interim relief. Again, we see a codification of the duty of candour, and it's put quite strongly, and it really, I can't emphasize how seriously it now needs to be taken. It's putting the duty of candour on a much more formal footing. And what I would suggest is that, given that it is now steps to investigate matters material to the application, one thing that is particularly key is if you haven't had a reply from the other side in response to pre-action correspondence, I think you've got to be getting on the phone. You've got to be getting on the phone and saying, I've sent you these letters, I haven't had a reply. Have these been received? I mean, it's always been a helpful thing to do in any event, but now it's really something which is quite essential. Applications for expedition. Again, we know from the recent case law that this is something that shouldn't be on an N463 really, or at least only when you are also applying for some form of interim relief. You must now include a statement of the position of the defendant. And so again, if you haven't heard back from the defendant, it's time to get on the phone to find out exactly what their position is. Applications for renewed permission. a lot of this is fairly similar to what it previously was, but there are some changes. So the application for renewal must now address the reasons given by the judge who refused permission on the papers. Again, it was always sensible to have done this, but now it's a requirement. The standard time estimate is 30 minutes. If you want more than that, and in most cases, I think we probably are going to want more than that, we need to specifically request it now. Something that's a bit odd about the new rules is that the court must be informed of an agreed time estimate. And the reason why this is odd is that, of course, renewal hearings aren't something which would typically be attended by the defendant. So it's a bit unclear as to why they should be being asked for their agreed time estimate when they're not even going to be there. But anyway, that's what the rules say. Additional grounds of claim. This is something that's really following on from the Dolan case. So in Dolan, one of the things that the court expressed concern about was the appropriateness of what were described as sort of rolling grounds of judicial review. So the idea that you issue your claim and then perhaps the defendant issues a further decision or amends their policy or gives some further explanation for a decision that has already been made. And at that point, you want to amend to deal with the new situation. And of course, this happens all the time, but it can get to the point where ultimately your final judicial review is very different from the original judicial review which was issued. And in Dolan, the Court of Appeal said, well, actually, maybe a line needs to be drawn in the sand and you need to just issue a fresh judicial review. And so that's why really this process has become a little bit more codified. And also, again, it's this emphasis on complying with the other rules that are under the civil procedure rules. So you have to make an application in the normal way. It must be made promptly in the normal way. It should be accompanied by a draft of the amended grounds, again, in the normal way. All of these things are something which you would be used to in making applications to amend in any other sort of case, but perhaps in judicial review, it hasn't always happened.
Right.
Skeleton argument. I'm not going to trouble you with too much. Let's just skip through that. Main change there is that there is now a page limit, and importantly, this sanction for a skeleton argument which does not comply with the rules. Non-compliant skeleton arguments may be returned by the Administrative Court Office and may not be refiled unless and until it complies with the practice direction requirements. If you are filing a skeleton argument late in the day, it had better be compliant, because otherwise it's going to get sent back and then you're going to be out of time. Documents which are to be filed before a hearing. It's just a lot more prescriptive than it was before. So an agreed list of issues, an agreed chronology, an agreed list of essential documents. There's a lot more emphasis on the parties working together to try and put the case in a good condition for the court. There is an entirely new core bundle requirement. So where there is a bundle which exceeds 400 pages, which of course many bundles for a substantive judicial review are going to be 400 pages or more, then there needs to be a core bundle. So two bundles where the normal hearing bundle is going to exceed 400 pages. And here's the other new point. Solicitors for each party must certify compliance with the requirements. So again, that is something which is new. Electronic and hard copy hearing bundle, again, 21 days before an agreed authority bundle. Again, that is not exactly rocket science, but it is, again, more strict, more prescriptive. I'm not going to talk about listing policies, but finally, agreed final orders. And this is something which is important to note because, again, it's something which is brand new. So where you settle a judicial review, there must be 3 copies of the proposed agreed order lodged with the court and a short agreed statement of the matters relied on as justifying the proposed agreed order and copies of any authorities relied upon. Both the draft order and the agreed statement must be signed by all parties to the claim. So that is really quite different from what we have had before. And I think that is it for my part. So as I say, my part was the stew, and now you have your pudding to look forward to.
Thank you, Sarah.
Thanks, Sarah. Oh, sorry, go on, Vicky.
I was just going to say thank you and pass over to you, Derek.
All right, thank you. Right, so tonight I'm going to be speaking first about everyone in, and then about the Judicial Review in Courts Bill, which was just presented to Parliament today. So starting with everyone in, next slide, please, Sarah. I'm not going to go into the background too much, as I'm sure you're all fairly familiar with it. Just a few key points. The Everyone In initiative was announced on the 26th of March last year. On the 28th of May, Luke Hall MP sent a letter to local authorities, and that was the first time, as far as I'm aware, that the government mentioned people with NRPF or who are not eligible for statutory homelessness assistance. And what the letter said was that local authorities should use their judgment in deciding what support they can lawfully give, considering each person's circumstances and support needs. So it didn't say that they should avoid accommodating people with NRPF or that they must not do it. It just said that they need to consider the legal position. More recently, on the 5th of November, the Protect program was announced. This is a new scheme which was essentially targeted funding that I believe was sent to only specific areas that have large numbers of rough sleepers. And there was meant to be a focus on providing accommodation and other services for the most vulnerable rough sleepers. But the press release announcing the Protect program made it clear that it was meant to run alongside Everyone In. Next, please. So the next big event was the Nkube judgment, which was handed down in March. Mr. Nkube was a former asylum seeker who was sleeping rough in Brighton. Brighton initially had a policy of accommodating all ineligible rough sleepers. They basically said, if anyone's sleeping rough, we're going to accommodate them, no questions asked, essentially. Then Mr. Nkube was subsequently told that Brighton's position had changed and they considered that their own policy was unlawful because they had no legal power to accommodate people who were ineligible for statutory homelessness assistance. Mr. Nkube was represented by Martin Westgate QC and Josh Hitchens, and in the JR, there were 10 issues involved, but I think for present purposes, we don't need to go through all of those. I'm going to focus on just 2 that I think are coming up most often in current cases, and that I think are most beneficial to most of our clients. So that's Section 138 of the Local Government Act 1972 and Section 2B of the NHS Act 2006. Next, please. So Mr. Justice Friedman held that local authorities do in fact have powers to accommodate under both Section 138 and Section 2B, with the caveat that neither of those provisions may be used to circumvent the prohibition under Section 185 of the 96 Act. So in other words, you can't just try to get homelessness accommodation through the back door by relying on these provisions instead. The actual terms of the provisions must be met for accommodation to be provided under them. And what I would say about that is that I think it's probably best practice to either, if time allows, have your client make a homeless application first so there can be no question. If you're certain they're going to be found ineligible, then that's fine. If there's a chance they'll be found eligible, then that's even better. Failing that, if you don't have enough time to go through the homeless application process, then you should at least make it clear to the council that your client does not contend that he or she is eligible under Part 7 and is not seeking temporary accommodation under Part 7 at all. Next, please. So turning to section 138 of the LGA, there are basically 4 elements to the test that are relevant here. The first is that there has been some sort of emergency or disaster, or one is imminent, or there is a reasonable ground for apprehending such an emergency or disaster. The emergency or disaster must involve danger to life or property, and it must be likely to affect the council's local area or some inhabitants of the local area. If all of those conditions are met, then the council has quite broad powers. What it says is that they may incur such expenditure as they may consider necessary to avert, alleviate, or eradicate the emergency or disaster's effects or potential effects. And in Nakube, the court found that in Brighton, even at the time when they were in Tier 1, back when we still had the tier system, it was enough to constitute an emergency or disaster involving danger to life. And even if it wasn't, then one was certainly imminent. The court emphasized issues such as the fact that there were still restrictions in place in Tier 1, and that there was ongoing monitoring to decide whether their tier should be increased. I think at the present time, obviously, we've just had Freedom Day, and I can imagine a lot of councils and probably a lot of judges will rely on the fact that there are basically no restrictions now. So I think as a practical consideration, it's probably best to point out that even now that we're all free, the situation is still being monitored and restrictions could be put back in place at any time. I was just reading today that I believe Sage was saying that we might need to bring some restrictions back as early as the beginning of August if hospitalizations pass the estimate of whatever it is, 1,000 to 2,000 per day. So it's best to, I would recommend keeping in mind that if anyone says it's not an emergency or disaster now, first of all, that's rubbish. But second of all, it could get worse at any time. The trajectory is that it is getting worse now. So at a minimum, an emergency or disaster is imminent. Next, please. Right, then section 2B of the NHS Act 2006 says that each local authority must take such steps as it considers appropriate for improving the health of people in its area. And those steps may be taken to include providing assistance to help individuals to minimize any risks to health arising from their accommodation or environment, and making available the services of any person or any facilities. So the key question here is that, does the provision of accommodation fall within the target of addressing public health functions? So in other words, you should focus on not just the health of your individual client, but the health of the public at large. So for example, let's say that your client were to test positive for COVID or become symptomatic. If he or she has no accommodation, then they'd be forced to rely on public hygiene facilities, and so they would risk spreading the virus to other people. And I think it might also be arguable that, particularly for people who are vaccinated, there's a higher risk that they could have asymptomatic disease. So even though they're not showing symptoms, they can still spread it to other people. So I think that may be a decent argument to make for clients who are vaccinated. So I'm hearing anecdotally about a lot of people who are being refused accommodation, at least in part on the basis that they're vaccinated, and so they'll be fine, basically. The language of section 2B talks about what each local authority considers appropriate. I'm not sure that there's any case law on this, but I'd imagine that whether a step is appropriate is likely a decision for the local authority, challengeable on the basis of rationality, in the same way that what is suitable is a matter for the local authority. So that's probably a fairly high bar to get over. Next, please. There are a few pending judicial review claims right now that I wanted to mention. There is a claim against Lambeth London Borough Council that's being brought by LawStop, and the claimant in that case is an ineligible and unvaccinated 68-year-old. And that claimant is arguing that the discretionary powers that I just referred to should be exercised irrespective of whether everyone in is ongoing. I think that's an interesting case because that will speak to if and when everyone in does end, and the extent to which local authorities can be called upon to exercise those powers regardless. As far as I'm aware, I spoke to the solicitor on that case a few days ago, and they're still awaiting permission, I believe. There was a case against Lewisham brought by Morrison Spowart, and basically in that case, Lewisham accepted that the pandemic is an emergency as defined by the Local Government Act, but they disputed that they were required to accommodate people with no recourse to public funds. The claimant basically ran a couple of human rights arguments under Articles 3 and 8, and permission was recently refused on that, unfortunately, including on renewal, and I believe an appeal as well. My understanding is that the courts were not very receptive at all to the human rights arguments. There's a case against, well, a pending case against Tower Hamlets. This is actually one of my clients, and I've just sent a pre-action letter a few days ago. I'm running a series of arguments there, which I won't go into because it's very early stages right now. They've just asked for a few more days to reply, but it looks very likely that they're going to refuse to extend my client's accommodation. So that could be another one in the pipeline. Next, please. So the one case that does have permission, as far as I'm aware, is also one of my cases, and it's called ZLL and Camden. And ZLL is a Chinese national and an overstayer who's been in the UK for about 18 and a bit years. He has no underlying health conditions, but he's not vaccinated. And essentially his background is that he was living in various hostels since the start of the pandemic. His winter night shelter ended, and he was being put up in hostels essentially on a week-by-week basis by a charity. He was referred to me by the charity, and I contacted Camden and requested accommodation under everyone in, citing Nakube. And they essentially said that everyone in had been superseded by the Protect program, which is something I've heard from other people as well. And so they're not going to accommodate him. Everyone is over, he's on his own. If he does need assistance, then he should contact their Roots Off the Streets team. He contacts the Roots Off the Streets team, which is basically an outreach service for rough sleepers. And they ask him to confirm where he's going to be the next morning between 5 and 11 a.m. And he says, well, I'm going to be in this hostel. What are you talking about? And they don't offer any help. He tries again another day at my insistence, and they tell him the same thing. So I have him go in to meet with them with his charity support worker. And they explain a bit more about how the Roots Off the Street service works. So basically you need to tell them where you're going to be bedded down on any given morning. And they send outreach teams to various areas of the borough to go and look for you. And what they explained to my client was that the outreach teams are small, and so they can't cover the entire borough in one day. But they usually, if they know a person is bedded down in a particular area, they try to get there within 3 days. So here we had a person who's been homeless for about 15 years. He's in a hostel and is about to be sleeping rough yet again. And the council has an opportunity to prevent it. But instead of doing that, they say, no, you must actually go and sleep rough, and we'll try to come find you within the next few days, and then we will let you know if we can offer you any assistance. And even then, there's no guarantee of accommodation. In the end, Camden still refused to accommodate him, but they slightly changed their argument. They denied saying that everyone in had ended, but said that basically at this stage, they're only helping people in line with the Protect program, which referred to people who were symptomatic or tested positive, people who were sleeping rough during the winter restrictions that have now fallen away, and long-term rough sleepers, which my client is anyway. Then the final point that they argued was that they were not satisfied that there was an immediate risk to my client's life, which obviously is an extremely high threshold to get over. Next, please. So we ended up issuing our claim. I've instructed Josh Hitchens, who was junior counsel in Nakube. And at the moment, we've got 4 grounds, although we may be amending these soon after some conversations I've had with Jamie Burton QC. Our first ground is that a failure to accommodate a rough sleeper during the pandemic will automatically be a breach of Article 3. And also that Camden's requirement that a person must actually sleep rough before assistance is offered also breaches Article 3 as inhuman and or degrading treatment. The second ground is that Camden have made a mistake of fact or law. We've argued that because they don't have their own published policy relating to everyone in, they have effectively adopted everyone in as their own local policy. And they've failed to appreciate that under everyone in, they are required to accommodate not just people actually sleeping rough, but people who are at risk of sleeping rough. Next, we've argued irrational arbitrariness, which basically is an argument about a failure to adopt a clear policy or criteria for the use of their powers under the Local Government Act and NHS Act, because they basically just said things that are completely irrelevant to those statutory tests. And finally, we've argued that they've acted contrary to statutory purpose, basically for the reasons I've already said. Next, please. So happily for me and for ZLL, permission has been granted on all grounds. Shelter has provided a witness statement dealing with some of the issues around rough sleeper verification and also results of some FOIs that they've done about everyone in and local authority move-on plans. They've not published that information yet, so I'm not able to talk about it, but I think they're hoping to publish it by the end of this month. And Liberty is also considering whether they want to intervene in the case. We don't yet have a hearing date, but we're hoping to apply to get listed during the summer vacation, because obviously we're keen not just to get a good result for this client, but we feel that some guidance is very desperately needed given all of the confusion that's happened in the past, well, couple months really. Next, please. And speaking of the confusion, there has been a lot of talk recently about whether everyone in has ended or not. A lot of it stemmed from a tweet from Oxford City Council on the 2nd of July, where they said that the government has instructed councils that they should no longer be accommodating people with NRPF. And then Lucy Heath published an article in Inside Housing on the 6th of July, essentially confirming the same thing. Apparently what happened is that the government sent a letter to local authorities telling them that they must stop using hotels and other emergency accommodation by the end of Q1. It also says something very strange, that funding for immigration advice is not to be used to challenge immigration decisions made by the government, but that's, I suppose, for another talk, but concerning nonetheless. Next slide, please. But since then, MHCLG has made it clear that everyone in has not ended. They published an article on their blog on the 7th of July confirming the same. The article did not say anything about people who are ineligible and whether they should be accommodated, but given the numerous statements that everyone means everyone, I think it's fair to say that the expectation is they should be accommodated. Also on the 19th of July, just a couple days ago, Eddie Hughes MP, who's the Undersecretary of State for Housing and Rough Sleeping, was asked about councils reporting that they've been told everyone in was over. And he said, and I'll quote this because I think it's quite helpful, "It is categorically not the case that either charities or local councils have been instructed as suggested. And indeed, the funding through the Rough Sleeping Initiative is continuing to fund people who are in emergency accommodation." So the question is, how does the government, or how do local authorities reconcile the public position, which is that everyone in is ongoing, with the private position, which is that emergency hotels should no longer be used? And how does that sit with this government's commitment to end rough sleeping by the end of this parliament? I don't know how they justify those two things at the same time, but then we're all familiar with the modus operandi of this government, and it's not particularly surprising. And then I think there obviously are some outstanding questions about what everyone in will look like now that we've had Freedom Day and at the same time are having this massive third wave of COVID cases. Next, please. So to give some practical tips about running these types of cases, some considerations that you should have in all cases. Does your client have any alternative routes to accommodation? So under Part 7, under the Children Act, the CARE Act, asylum seeker accommodation, if the problem is that they have an NRPF condition, then can you challenge that to try to get the condition lifted? I think you need to be very, very careful if there is any sort of alternative available, because obviously if you rush off to court on a JR and you have an alternative remedy, then it's not going to go well for you. But I think it is worth considering how long an alternative option might take. So for example, if a person needs to apply to have an NRPF condition lifted, that can take quite a long time. And if they're going to be sleeping rough in the meantime, then you need to consider whether, well, basically whether that's an acceptable situation. Consider whether your client is particularly vulnerable to COVID. Are they vaccinated? Do they have underlying medical conditions? Are they of an advanced age? Does their ethnicity make them more vulnerable? Ethnicity is a tricky one because the scientific evidence is a bit complicated. You should ask the local authority whether they have any policies related to everyone in. So I think some have produced policies, some have not. Has the local authority provided reasons for refusing to exercise their discretionary powers? And if their reasoning is based on a lack of funding, how is that rationally connected to the discretionary powers? You should try to get them to focus on the statutory tests under the LGA and NHSA. And if you have a client who's already in everyone in accommodation, but they're being evicted, then you should look at how the situation compares from when they were first accommodated to now. So for example, the case I have with Tower Hamlets, his accommodation was extended in November when the situation was actually slightly better than it is now. So the argument is, how can you rationally justify ending the accommodation when the situation is worse now than when you last extended it? Next, please. Moving on to the JR and Courts bill, the government very unkindly just presented this to Parliament today when I'm due to talk about it. So I apologize in advance that what I'm about to say is potentially quite cursory because I had about 35-40 minutes to put this all together. So if I've got anything wrong, just blame the government for not giving me enough time. Next, please. Right, so part 1, clause 1 deals with quashing orders, and it proposes to insert a section 29A into the Senior Courts Act 1981. And section 29A subsection 1 would provide that quashing orders may either not take effect before a date specified in the order, or remove or limit any retrospective effect. And either of these provisions may be made subject to conditions. So the conditions would be, for example, if the defendant undertakes to carry out a consultation or anything that might cure the illegality or whatever has brought about the order being made. Next, please. So if a suspended or prospective quashing order is made, the acts that are protected by the suspension or that predated the prospective order are treated as if they were valid and enforced. If a suspended order subsequently takes effect, then it can have retrospective effect, including in relation to acts done during the period of suspension. So what that means, as far as I understand it, is that say a quashing order is suspended for 2 months while the defendant does whatever conditions. If they don't carry out those conditions, if the conditions are not met, then the quashing order takes effect at the date in the order. And it can have effect on decisions that predated the order and in that interim period when it was suspended. And the court will have a power to amend the date in the suspension as well. Next, please. So the bill then lists a series of mandatory considerations that the court must consider when deciding whether to make a suspended or prospective quashing order. Not going to read them out to you, but basically it's a balancing exercise between the claimant and the defendant and the interests or expectations of persons who would be affected by the quashing order, as well as anything else that the court considers to be relevant. Next, please. So I think this is the controversial bit that people have been focusing on. And this is from what would be section 29A9. So it states that if the court is going to make any quashing order, as far as I read it, and it appears to the court that an order including provision under subsection 1 would, as a matter of substance, offer adequate redress in relation to the relevant defect, then the court must exercise the powers in that subsection accordingly, unless it sees good reason not to do so. In other words, if the court thinks that they can make a suspended or prospective quashing order, and that will adequately provide adequate redress, then they must suspend, or they must either suspend the order or limit its retrospective effect. So this is the concern that people have, because we don't obviously know how the court is going to weigh up the factors on the previous slide in section 29A8, and we don't know how they're going to assess adequate redress. But I was thinking about this, and I was wondering whether if an order is going to be prospective only, and then how could it offer any redress to the claimant who brought the claim? How could that ever be adequate? If it only affects future decisions, then it just seems a complete nonsense to me. I mean, hopefully that means that prospective orders will only be made in very limited circumstances, but I suppose that remains to be seen. And one thing that I should note is that it's arguable that courts already have these powers, despite them not being in statute. There are a couple of cases that I don't have to hand, but the courts essentially said that in appropriate circumstances, a quashing order can be suspended and its retrospective effect can be limited. So potentially, I think this may not change things too much. I'm not as worried as I was having read the government's response to the independent review of administrative law. Yeah, I was expecting worse, and I think it's a pleasant outcome in the circumstances. Next, please. So this I came across towards the end of the bill. This I think is even more controversial. I say that only partially tongue-in-cheek, and I apologize to the non-Londoners in the audience who will not be able to relate. But clause 43 of the bill amends section 29 of the Courts Act 1971, and it would remove the duty on the Common Council of the City of London to make the premises of the Mayor's and City of London County Court available for the sittings and business of that court. So I think what that means is that, well, probably they're just going to sell that court off to the highest bidder and it will be turned into some luxury flats or whatever else. And more of us are going to be queuing for the lifts at central London. We'll see. I mean, I guess that's the direction of travel anyway. So again, not particularly surprising, but there we are. Next, please. Right, so I think just a couple of things worth mentioning. Part of what was proposed in the independent review of administrative law and in the government's response have not made their way into the bill. And those are actually things that I was looking forward to. One of them was to remove the requirement to bring proceedings promptly. They were going to get rid of that and just make you bring the claim within 3 months. That's not in the bill. And the other was to amend CPR Part 54 to provide for claimants to file a reply after an acknowledgement of service. That's not made its way into the bill either. So that's a bit of a disappointment, but yeah, it could be worse. Trying to stay positive.
Thank you. So has anyone got any questions? Simon, I'm not sure if anyone's email or sorry, put anything in the chat directly to you. I don't really have any questions apart from just generally being quite scared at Sarah's talk, which I think is the kind of probably the prevailing view and probably a good thing, because if we're being scared now, it probably means we're less likely to make mistakes at a later date. Anyone?
I can pitch in with a question while everybody thinks of the questions that they want to ask. This is for both of you, really, to do with Incube. I find the bit about section 185 and not circumventing section 185 quite a confusing sort of piece of the judgment. I find it hard to read and hard to understand. So I wonder if between the two of you, you could just unpack that a little bit. I suppose I'm thinking not just of, I am thinking of people who are ineligible due to section 185, but also other clients of ours who may be unable to access mainstream homelessness services through a finding of not in priority need, or a finding of intentional homelessness. Whether you could just unpack that bit of the judgment for us a little bit.
Derek, you want to go with that?
Yeah, so it is a bit odd. I mean, I think my understanding of it is just that the court wanted to avoid local authorities very generously handing out temporary accommodation where the provisions of the LGA and the NHS Act were not met. So, for example, if there was a person who is not eligible under Part 7, but is in need of accommodation, they didn't want just accommodation to be given out to anyone unless those provisions are met. I don't think that's really a realistic concern. I don't know many councils that just rush to give out temporary accommodation to people. Yeah, I don't think it doesn't particularly concern me, because the whole argument, the whole reason this exists is because of everyone in, and everyone in exists because of public health concerns and the ongoing emergency. So I'm not sure that should cause too many problems in practice.
Yeah, I think I would agree with that. But if I can perhaps turn the question into something practical, I think that whenever you're dealing with other routes into some form of emergency housing, whether it's Children Act or however you're trying to obtain housing, I think strategically it's incredibly important to make it very, very clear from the outset what your expectations are, and to make it clear that you are not seeking to be provided with a secure tenancy, that you're not trying to get some sort of social housing through the back door. And I think if you make it really, really clear that that's what you're doing, and you sort of manage the expectations of both the court and the council, I think you have a lot better chance going forward. You know, that case was looking at emergency accommodation, and you just have to be really clear that that's what you're asking for. You're asking for emergency accommodation because of the pandemic. And if you stay focused on that, I don't think that part of the judgment is a problem.
Thanks very much.
Sorry. I have a question. Olivia, would you like to ask the question, or should I ask it for you?
I'm happy to ask it. So basically, we found that the threshold for JRs is so high that most barristers that we instruct won't find that there's reasonable grounds or reasonable prospects of success. So we almost never do our JR claims, even where there's failure to provide temporary accommodation or what have you. So I'm just wondering if these are like even higher threshold now, even more barriers, and if anyone's ever going to be able to do. Am I just being very negative? I'm just wondering if anyone's ever going to be able to do a JR ever again.
No, I don't want to discourage you from taking judicial reviews at all, not least because although we're talking about some of the more challenging judicial reviews, or at least Derek's been talking about some of the more challenging judicial reviews, actually an awful lot of judicial review work in housing is really straightforward. It's because of gatekeeping, or it's because of some, really blatant error that the council is just, hoping to get away with. So, I think actually in judicial review cases, I'm quite often assessing the merits really high, because it's stunningly obvious what they've done. I think what we probably are going to be quite terrified of is just really making sure that the arguments have been put to the other side and that we've made proper inquiries of our clients, because clients quite often say that I don't have anywhere to go, or or I've got these health problems or whatever, and on a bit of prodding you can find that actually maybe they do have somewhere to go. Maybe it's not great, but they do have a roof over their head, and perhaps their health problems are not as serious as they might at first indicate. And so I just think it's a little bit of pushing your clients, making sure that your instructions actually stand up to scrutiny, and making sure that the other side have been put on notice. I mean, something that I see quite a lot in gatekeeping cases is where emails perhaps with a pre-action protocol letter have been sent to a generic email address, or perhaps to a solicitor who had conduct of a previous case and who we know works dealing with housing cases, and no response is received, and we just sort of leave it at that. And it's sort of fine on paper. You can say, yes, we sent this letter and that letter and this letter, and we didn't get any response. I don't think that that's really good enough. I think you've got to really, again, push it a little bit, find out from the defendant, have they actually got those emails? Has someone actually opened them? Have they really been given an actual opportunity to respond, as opposed to a sort of technical opportunity to respond? So I think it's just a little bit more rigor in the way that we issue these claims, or at least urgent claims. But I absolutely don't want to discourage judicial reviews at all. None of the procedural rules that I've talked about go to the merits of the case itself. It's just about making sure that everything is done properly.
So have we got anyone else? I like Olivia's just put a few in the chat, so that's good. Have we got anyone else that wants to add to this? Any other cases that people are dealing with everyone in and different local authorities? Okay, so right, so I think well, we've got, I think Sue wanted to come in with a comment. Sue, if you wanted to unmute yourself. Maybe not.
Sorry.
Oh, hi, sorry. I didn't know if you were there.
I'm sitting in the garden there. Yeah, hi. I was just thinking about legal aid in relation to the retrospective benefit, and it's something that has been raised before, but it worries me that, you know, how are you going to justify that on your legal aid application if your client gets no real benefit from, you know, challenging a decision that's been made? So, Derek, any thoughts?
I suppose you just have to fall back on wider public importance. But yeah, strictly speaking, there's no benefit whatsoever to your client apart from the happy feeling they get from changing the law going forward. So I don't see how you can justify legal aid for the vast majority of cases. But so I think the way that you would handle it is to argue the reasons why the court is unlikely to make it prospective, because that wouldn't provide any benefit to your client. It wouldn't provide adequate redress, is the language that the bill uses. So, you know, if it's a gatekeeping case, refusal to accommodate case, that sort of thing. Obviously, if it's not retrospective, then it has no benefit to anyone whatsoever.
I mean, we're very often asking for mandatory orders anyway, so that, you know, in most cases, a quashing order isn't really going to cut it for our clients, at least for the vast majority of housing cases. I mean, I think the new bill is really directed at the sort of big, grand political policy challenges rather than the sort of run-of-the-mill housing cases, which most of us do. And because I think, Derek, you're right. I mean, how can a prospective order ever be adequate remedy for someone who personally has actually suffered some adverse consequence which needs to be remedied?
Sorry, I'm just finishing.
Actually, Abhikar, you had a question there. Do you want to come in and ask that? It's another interesting legal aid question, I think.
Hi there. Thanks everyone. It's essentially in regards to Section 17 challenges. One of the questions that we get posed is realistically, if a client comes in and it's gone past the route in terms of a homelessness challenge where the local authorities made a decision and they're now in Section 17 accommodation. If the authority are now seeking to end Section 17 accommodation itself, and it's in view that they consider that the children are no longer in need, what is, at that stage, would it be correct, in my understanding, that it's a community care matter to be handled under a community care legal aid contract?
I've got a visual kind of answer for you, Abhikar. Not related to the fact that both Sue and myself are involved in this book, but this excellent book, I think, does tell you that those cases can be conducted either under a housing contract or a community care contract. So you can take your pick, actually.
That's helpful. Thank you. Thanks, Simon.
Right. Any other questions? Anyone else want to make any other comments? So I'm going to leave with so another plug for the podcast, another save the date for the housing conference, which is the 9th of December. Look out for the survey, and most importantly, a very, very big thank you to Sarah and Derek for today's presentations. It's been really, really very, very useful. I think I've got a lot out of that. And this session has been recorded as well, so I think that will be I think that will be available on the HLPA website. So if that's all, if no one else has any other comments, I will close the meeting and leave the Zoom. Enjoy your evening.
Thank you.
Thank you.
Thank you.
Thank you.
Bye-bye.